Where are we, Joe?
So we're at Times Square Diner at Wilson Heights in Wilson, and we're at the edge of the Bathurst Manor area, which is where I grew up when I came from Montreal originally, and I went to school at William Lyon Mackenzie Collegiate, and we used to come over here at lunch to have French fries or have a snack. And this, if I'm correct, this restaurant's been around, this diner's been around since 1950 something. These are different owners, but they've been here forever. Family works here.
It has that feel to it too.
It's great. They actually shoot films in here because this is like an old style diner. And by the way, everybody, welcome to Defenders and Diners.
Yeah.
Defenders.
A subcategory of not on record.
Why not?
Defenders talking about cases at diners.
It's great.
Isn't the Good Bagel place up the street?
I'm sorry, I can't talk bagels when I'm in the home of the best banquet burger I find in Toronto.
And you always know. You always know.
Banquet burgers are, and frankly the hot face
comes our waitress for
chicken
tonight.
sandwich is great. Oh, thanks.
Oh.
Thanks, honey.
Thank you.
Thanks, Marcy.
I'll be back to take your order in a few minutes.
Ma'am, may I have a cup of tea?
Oh, I would.
That'd be lovely, thank you.
Wow, Marcy works here. I didn't know that.
So,
Good gig.
Sexsomnia.
All right. Okay.
It's
so
not on the menu, by the way.
It's item
not.
32.
That's item 30. It is on the menu. I didn't
It might
know
be.
that.
I hope nobody falls asleep during this episode
right, no.
when we talk about sexsomnia.
Don't make me laugh.
No, too late. Too late.
So we thought about this because we have a case, which it's very
God,
rare.
She's so fast. You're
Oh,
gonna have to
thank
tip
you
her
so
well.
much.
I've had lots of practice.
No tip for you.
No tip for you.
Can I get a tea as well, though?
Sure. And Burry, what would you like?
Just ice water.
ice water.
Yes, shaken, not stirred, or whatever.
So, so you mentioned this topic, and this is something that we've kind of encountered it in a few different ways, similar defenses, but this is very specific, and it's something that people don't really talk about much because it's such a rare defense.
Yeah, and I think it's sort of a vilified defense, but we have one case now where we're just considering and exploring it. And so sexsomnia, just for everybody knows, is a legitimate defense, and it's known as sleep sex. It's a distinct form of parasomnia, or an abnormal activity that occurs while an individual is asleep, and it's a subcategory of sleep disorders.
Yeah, it's a sleep disorder.
And the reason it's referred to this is because it's a disorder that has a sexual component to it.
So this is a defense that people don't really understand very well, I think, because
Excuse me, our waitress is back.
Oh, thank you so much. They're so efficient here.
You are, and you're so good at not spilling stuff. I would have
Are you guys ready
tossed
to order?
that.
Give us a few minutes, ma'am.
Not a problem.
Thank you.
So
You're just lapping this up.
I love this, Defenders and Diners.
It's perfect.
Okay.
Never been done.
So this is one of these things that people get upset about because people are found not responsible, even though they're found to have committed the crime.
Right.
Right, so they've committed the actus reus, but the mental element isn't there because they're acting involuntary.
Right. So they don't deny something happened. It's just, why did it happen?
Yeah, and this defense is not something that people can just get away with something by saying, I'm sorry, I was asleep. It's very difficult to prove, yeah?
It's very difficult to prove, and let's just back up for 1 second. So sexsomnia comes under the sleep disorders, which is under the DSM-5. So there's criteria for it.
DSM-5
Explain what that is.
It's the diagnostic manual in psychiatry and psychology for diagnosing disorders and mental health issues.
So what does it typically show? It'll have
Well, symptoms so there are a number of sleep disorders. Sleepwalking,
walking, talking,
sleep
driving.
apnea.
We've had in Canada.
Yeah, so people can conduct themselves while asleep and do complex motor skill
They can
activities.
engage in actions while they're asleep.
But typically these disorders are divided into arousal disorders, sleep-wake transition disorders, or parasonomas associated with REM sleep. This one is a non-REM sleep disorder.
What does that translate into?
Rapid eye movement, but
Okay.
it's just how they're
Got it.
designating it. But symptoms of sexsomnia, and listen to this, can include masturbation, oral sex, groping,
At the right time.
fondling.
Hello.
We're just having a private moment.
Wow. May I push pause?
Pause.
Sure.
Moment, please. Can I take your order, lovely lady?
Oh, thank you. Yes, I will have the souvlaki dinner With chicken?
And it comes with a Greek salad. Are you okay with that?
That's great. Thank you.
Wonderful. And
What do you recommend tonight?
I actually already took your order. It's on the paper. We'll surprise the bury.
She's going to surprise me. I love that. That is so
Husband, what would you
exciting.
like?
Banquet burger.
I already wrote that down. And what do you want on your burger?
Okay, mustard,
She's intuitive.
Yes.
Yes.
relish,
Yes.
onion,
Yes.
mayonnaise,
Yes.
tomato. I'd like a side of French fries
Yes.
and excessive gravy.
Oh,
And a
this is
pickle.
this is going to be messy.
No pickles for me.
No
No,
pickles?
he wants a pickle so I can
Okay,
go.
I'll take a pickle on the side.
Have pickles.
I don't know either.
Yeah.
Yeah, if
It's
they
not a-
do.
It's not a deli. It's a diner.
Okay.
The wrong
Well,
D.
no, they actually have deli
The wrong
sandwiches.
D. D.
Okay, well, I'm just saying if they have pickles, I'll
Thanks,
take
thank
one.
you.
She'll have his pickle. But bump.
Oh, okay, thank you.
But what if we want dessert?
That'll come next.
We'll deal with that later.
Intercourse with climax, sexual assault or rape, moaning, dirty talk while asleep,
Masturbation.
masturbation we mentioned.
Oh, okay, I didn't touch it.
Sexsomnia often causes self-touching or sexual motions. It can also cause individuals to seek out sexual intimacy with others unknowingly. Sexsomnia may also occur at the same time as other parasomnia activities such as sleepwalking or talking. Sometimes it is a partner, roommate, or a parent who's first notices the symptoms of the condition. Sexual partners might also notice their partner as having abnormally heightened levels of sexual aggression and decreased inhibitions randomly at night. This is a real
It's a real thing.
Studied phenomenon, but
phenomenon. It is under the DSM-5. So we're not talking about something that's made up
Right.
to get
off.
get off of an offense.
No pun
And to be
intended.
clear, it's not only men who experience this. That women can. It's primarily been noticed in men, but women can also experience the same phenomenon.
Yeah, predominantly
Different
it's men.
ways, but it's predominantly
That
men.
is absolutely correct. So it's not, it's not an offense that's easy to establish as well, which is what you mentioned. Now, let's just draw one other distinction, and then maybe one of you can talk about what the actual, what the threshold is in a legal test. But it's an offense that's based on automatism. It's a defense, sorry, based on automatism. There's a burden on the accused to establish this defense on a balance of probability.
That's an important point to emphasize. That the burden
onus
of
is
proof,
on the defense,
The burden
yeah.
of proof, and normally in a criminal trial, is on the Crown to prove that
Right.
the acts are met out and that they've proven their case. But when you raise certain defenses, the onus can shift, and this is one of those ones.
It's like there's a presumption that people are sane and acting voluntary. So you have to displace that by establishing your defense on a balance of probability. So that's not something which is easy at all in these types of cases.
Right.
And in Canada, these cases, and we'll get into this a little bit later, but they can be non-insane automatism.
Right.
One of their phrasing is mental sexsomnia or non-mental sexsomnia. The result at the end of the day is if it's established as a defense, it can result or will result in a finding of not criminally responsible, so that they are then brought into the mental health system under the criminal code, where they wind up in hospital.
So
And I
how's
want to
that
talk
different?
about that
Yeah,
in some
expand on
detail
that a
later
little
on.
bit.
Yeah, expand.
I'm
the
just saying it
difference
right
is.
now
Yeah,
because
yeah.
what's interesting is you can have an automatism defense, and you picked today a murder case,
Yeah,
Parks from 1992,
correct. Yes.
where there was a homicide by somebody who was sleepwalking, had no motive to kill, killed the parents, and it was established that in fact this was automatism, so they were acting involuntary and they were found not guilty. That was the end of it. But with these particular offenses, it's basically a policy decision where it's found to be not just having the mental health element to it, but also a policy element to it because there's future risk. And that comes from the case of Stone.
Right.
And you can read about it separately. But that's a significant thing because one might argue, well, if it happened once,
Right. It's a one-off.
it's a one-off.
Can it be a one-off, or if it's a disorder, is it likely that it could happen again?
Well,
It's
automatism-
a serious question.
Automatism
Right.
can also occur once or maybe more times depending upon the precipitating factors. So who knows? I see this as purely a policy decision. That's been okay according to the Supreme Court.
Which equals to put it bluntly, is you can never be found not guilty of this offense. Of this, if
Not true.
If you're using this defense.
No, you are not guilty.
Well, you're not guilty because
I want to be very careful with the terminology.
I know, that's
so
what I'm saying.
It's not guilty by reason of mental disorder.
Right.
So you are not guilty.
Right.
You do not have a criminal record that way, but you're found not guilty, not criminally responsible. So, yeah. So.
But if you're NCR, it doesn't mean that you get to walk free.
No. God, no.
No, there you would wind up then going under the auspices of a review board in Canada. Right. You will likely be in custody, although you could be out of custody on bail and be remanded to the hospital while still being on bail and have an outpatient assessment. And then there's a proper determination as to your level of risk and your health condition, etc. And maybe the person can be managed in the community, but it may wind up that the person is detained in a hospital in a various levels of setting. So it's a whole other regime for the individual to be supervised under, managed, assessed, etc. So it's not, it's
You're not getting off scot-free.
And I really do think
you're not. And then there's a cascading process there as to whether if they're detained in hospital but given privileges to live in the community. There's various things there. So I just want to draw the distinction. It's not criminally responsible. You are not guilty, but it's different than where you would be found not guilty and just gone. Yeah. Like an automatism defense, which was in that one murder case.
So yeah, so that's the thing I think the public takes the most concern with, is like a temporary insanity kind of thing, where they're saying that they're not, guilty by reason of a mental disorder, but they were temporarily not in possession of their mind, and therefore they're not guilty, but they're also not requiring any admission to a mental health unit. That's what I think the public quite often takes these NCR designations, and they think, oh, this is a travesty because this person committed a crime and got away with it.
Right.
In the majority of NCR cases, they're caused by usually an organic disorder. Mm-hmm. So I happen to author a book on dangerous offenders. It's a leading textbook in Canada on risk and assessment, and it deals with this. But the majority of those cases are organic disorders, where it's a disease of the mind. It's like schizophrenia, delusional disorder, bipolar resulting in psychotic features or delusional disorders. And so somebody commits an act where they don't appreciate the nature and consequences of their conduct, or they don't know that it's morally and legally wrong.
Right. Or in this case, they were asleep.
Right, but the issue with those is that it's no different than somebody having, God forbid, a heart condition, having a heart attack, the car goes off onto the sidewalk and kills somebody. You can't help that you had a heart attack. You can't help that you developed schizophrenia or bipolar disorder. So we treat people because they're ill, and then they wind up in the mental health system. Mm-hmm. This is slightly different because it is a disorder that emanates from a sleep disorder background, and there may be precipitating factors, because we've seen many of these where there's alcohol involved. Right. But it may very well be that it's easier to manage once somebody's diagnosed with this. But I want to be clear that because in Canada we deal with this, there's no temporary insanity with this, that doesn't exist. It was really a policy decision, and we've seen this in the case of Regina versus BM, 2018 OJ number 446, just one sec, where you can really see that this is a policy decision. Go ahead.
And just before we get into the more current cases, I just want to talk about, as you mentioned, this Parks case, because I think this is helpful, and that this is a case that doesn't involve a sexual assault. This involves somebody who actually murdered somebody while they were found to be in a state of sleepwalking. Right. It wasn't sexsomnia, but it's a similar kind of situation. And it's important to mention that this person was actually found to be in a state of non-insane automatism.
Right.
Automatism?
It's hard to say.
Say it
like
10 times.
Say it 10 times, you'll be fine.
But this person was actually found, there was in this case witnesses, and he unfortunately ended up murdering a family member, his in-laws, one of the in-laws, and he seriously injured the other one. And everybody agreed that when this act took place, he was not coherent. He didn't seem to know where he was. There was external evidence supporting that this person was not aware of what they were doing and where they were.
Yes, and they had no motive to commit the act that they did.
Correct.
He was, I believe his parents were the victim in it. So all those are relevant factors. So
that's important, I think, because people sometimes, I think, get stigmatized when it involves a sexual act. And it's important to remember that this defense, runs a little bit broader spectrum.
It's a good point. And again, this is a very rare defense. Like, we have to go searching for cases about this. So
Not a
when
lot.
people might say, well, this is, just they're drinking and they claim sexsomnia and they can just get off with sexual assault.
Not
That's
that
absolutely
easy.
not the case.
Yeah.
It's an extremely difficult defense that requires expert evidence and collateral evidence to support it.
And one of the problems is that one of the things that can trigger sleepwalking and such is alcohol
yeah.
abuse. So quite often these cases will be combined with alcohol abuse, and that makes it more difficult for the accused to successfully argue a sexsomnia situation, because it's equally open for them to find that they were just simply drunk.
So let me just set up like a fact scenario. I'm not going to talk directly about our case, but let's set up a fact scenario. And then Michael, you can maybe take us to sort of where the law has been set out as to what kind of the test is. I don't think it's actually the test, but it sets out a lot of parameters.
Yeah.
But let's give a fact scenario. So we have an individual who's married, and over the course of several years, he's alleged to have had sex and committed various sexual acts with his wife, the complainant, while he was sleeping. And the complainant in the statement had said, it seemed as though he was sleeping, he was not awake, not aware of what he was doing, yet he was committing these acts on me without my consent, and it started when I was sleeping and I woke up to what he was doing. And then he'd just stop after a while and go back to sleep. And then the next morning, she would say something to him and he'd say, I
have no idea what you're talking
I have no
about.
idea, I have no memory of what you're talking about.
Right. And that's a situation where there is some corroboration.
And from the complainant herself, that there is this history of this, and then with it, evidence that in fact there's loss of memory, there was no intent for him, there was no need for him to try and do this.
And a practical observation at the time of the alleged act, or the act that they're not even disputing because they can't say what was going on or not.
Yeah.
But there's some corroboration during the actual time frame that the person was not seeming to be of their normal self and not seeming to be aware of the situation.
And so, in order for us to try and develop that, or any lawyer to develop it, the accused would have to go through some testing. So it would be very important for him to see a sleep disorder specialist who's a doctor who specializes in that. There's a battery of tests that can be run, and they can do sleep tests, and you can see if there's sleep apnea, if there's disturbance of sleep, all sorts of issues that would be a factor in why this would happen. Probably seeing a psychologist as well, who would then administer a number of tests, including personality tests and other tests to determine if whatever they're speaking about with respect to their own self-report, because they could say, I have a history of sleepwalking, I have a history of waking up in the kitchen eating something and I don't remember it. So these self-reports can be tested to some extent with psychological testing to determine if they're malingering, what's the chances that they're feigning this or lying. And then you need an expert forensic psychiatrist who also would have some experience with sleep disorders to then assess, and then all who's involved, which would be the psychologist and I would say the psychiatrist and probably social worker, interview collateral sources of information. Could interview the complainant in the case, family, parents who might have witnessed sleep disordered issues. So that is a lot of evidence that would need to be gathered, along with fairly compelling psychological and psychiatric evidence.
Handoff, he's handing it off.
Well, so from a public perspective, if somebody has this recurring situation, is that not a risk to the public that we need to be concerned about, that this is a behavior that could repeat?
Yeah, I don't disagree with it. I that's why, and I think we'll come to it later on, which was, I think Justice Doherty had said that, you got to look at the ongoing risk, and you have to consider under Stone that risk as a factor in determining how you dispose of this case. Is it an NCR? But let's talk about, now that we've sort of set the factual parameters out, and
Handoff number 2,
what the
right?
matrix of expert evidence you need is.
So the law for tonight's episode really stems from one Supreme Court of Canada case. It's R versus Stone, 1999, 2 SCR 290. And they set out a pretty, I thought, clear definition, may not be easy to understand, but a good definition of this whole area of automatism and what it means. So first and foremost, at paragraph 171 of the judgment, they say, the law presumes that people act voluntarily. Makes sense. Accordingly, since a defense of automatism amounts to a claim that one's actions were not voluntarily, the accused must rebut the presumption of voluntariness, i.e., if you're claiming it, you have to rebut that presumption. So an evidentiary burden is imposed on the accused. And in particular cases of what that equals, the court said, firstly, there's two parts to this test. The defense has to make an assertion of involuntariness. That's straightforward. They have to say, I'm making this defense, I'm raising this defense. Secondly, they have to call expert psychiatric, as you alluded to, or psychological evidence confirming that assertion.
And to be clear, it's unlikely that you could succeed in this without calling an expert.
Oh, you have.
It's impossible.
It's impossible. It's impossible.
There's no way you could just testify and just say, this is what happens to me, and call some witnesses. Zero chance.
And even those two components are not enough. The court says the burden will generally require more than an assertion of involuntariness on part of the accused, accompanied by confirming evidence that automatism is plausible, assuming the account of the events given to the expert by the accused was accurate and truthful. In the second step, and this is the important part or piece, the trier of fact, in evaluating that evidence, must make a determination of whether there is sufficient evidence upon which a properly instructed jury could find on a balance of probabilities that the accused acted involuntarily. So that's a big hurdle. Mm-hmm. It's not just A plus B, I'm claiming it, here's my psych reports. It goes beyond that.
Say that again slowly so that everybody gets it, because it is,
And tie it into...
it's a huge hurdle, and there's only a few cases in Canada.
And we're talking about mens rea.
Right.
To be clear.
So again,
That's so sexist of you.
It really
How about
is.
people rea?
People rea. I like that.
Person rea.
Person rea. I like that. But then,
Sorry.
But then we'll get into pronouns. And
People
The T
rea.
makes me giggly.
It really does. Cut him off the T, Marcy. Okay, where were we? Two requirements again.
Yeah, just
for
read the second one
test.
about on the
The second part you want to hear, or the first
the
part?
second part.
Okay.
It's important for everybody to understand slowly.
Okay.
Because we're talking legalese now.
Yeah.
Yeah, I know. It's even italicized, so that means it's important if it's italicized.
And sometimes in Latin.
I'm not doing Latin tonight.
Okay.
This burden will generally require more than an assertion of involuntariness on part of the accused. So you can't just say, I claim it, therefore, accompanied by confirming expert evidence that automatism is plausible. So you can't just say, again, I'm claiming it, and here's a pile of experts' reports. Okay. In the second step, the trier of fact, the judge, in evaluating that evidence, must make a determination of whether there is sufficient evidence upon which a properly instructed jury could find, again, here's the test, on a balance of probabilities that the accused acted involuntarily. So again, it's not A plus B or 1 plus 2. The judge is going to look at a constellation of different factors in this case. So for example, in the case that I cited from the Supreme Court,
Stone.
yeah, thank you, corroborating evidence of a bystander that reveals, okay, the guy was off, he had glassy eyes, he was muttering, just it wasn't something I had seen before. That's one example of evidence. That's hard to say. Motiveless act will generally lead plausibility to an accused claim of involuntariness. For example, why would he do that? It makes no sense. He's never acted like this towards the complainant before, and then out of the blue, we have him trying to do ABC to
Let's
her.
put structure on that for a second. So, for example, in a case that we're examining, let's say the complainant and the accused had a very healthy and active sex life.
Robust.
Robust.
I love that
and
word.
so the instances that this happened, there would be no particular motive, because it's not as if...
It's not out of the blue.
No, and there has been no evidence of him being a domineering, abusive character in the relationship. These are relevant factors for this type of defense.
And that's important, because that's one of the points they make here too, is that where there's a motive to commit the crime in question, that
Diminishes your chance of
diminishes
success.
the chance of success.
Right,
yeah.
right. Hand off.
So can I just...
Yeah, go.
Just one sec.
He put his
So
hand up,
let's just take
actually.
the case of Regina versus Hartman.
Okay.
2015 OJ 554. So this was a Court of Appeal case, which
Right.
was interesting because the defense was not advanced at trial.
Right.
On appeal with new counsel, it was advanced,
Right.
and an assessment was done by Dr. 𝐕𝐈𝐃𝐄, who's a well-known forensic psychiatrist who has experience with sleep disorders.
Right.
And I'm just going to talk about what evidence was filed in the Court of Appeal, just so that there's some flesh to this, okay?
Talking about error of reality.
Yeah, well, just so everybody understands what we're talking about, this
And
evidence.
so folks understand, on appeals, fresh evidence can be tendered. So if you didn't rely upon it at trial, you can, in very specific circumstances, lead fresh evidence on an appeal.
It's not an easy threshold.
No, it's not
But
an
the
easy-
only reason I'm referencing this is just to give
Right.
an example of what type of evidence you may want to gather
Right.
and then marshal to try and have the defense. So in this case, the accused, it's the appellant, but I'm going to say the accused, filed a sworn affidavit himself, as well as affidavits from his mother, his girlfriend, and 2 reports and 3 affidavits from the doctor himself. The Crown cross-examined all of them on the affidavits. Dr. 𝐕𝐈𝐃𝐄 gave opinion that the accused was likely asleep when he assaulted the complainant. There was evidence emanating from the affidavits filed by the accused of a history of sleepwalking as a child, the family history of sleepwalking, so that was within the family as a known disorder, and other incidents of sexsomnia witnessed by the appellant's girlfriend. Dr. 𝐕𝐈𝐃𝐄 relied on some of that evidence in forming his opinion. And I don't want to talk about the competing opinion, but that is a grounding of evidence
Right.
that's helpful. So, for example, the girlfriend said, no, he's done this actually to me, or I've witnessed him try and do this. And so there is a historic basis within the family.
Right.
There's a historic basis with him being a sleepwalker as a child. There is a temporal connection and
Paragraph
evidence.
34 sets out all the factors that the court said Dr. 𝐕𝐈𝐃𝐄 relied upon. They're quite extensive.
Sure.
Yeah.
Do you want to read from paragraph 34?
Well, no, I'm still back on the case that we were talking about
Here's
before.
paragraph 34.
But I can read paragraph 34. My glasses.
It's just it's
It's
good.
interesting.
It's
There's a
good to
number of
flesh
No,
it
it's
out.
interesting because it shows the extent of preparation and work that has to be done in
it has to
establishing
be very
this.
thorough and it has to have an air of reality, which is kind of
Well-
what we were going to get to. But he was in an appeal, it has to have had a material bearing on the outcome of the case.
Right.
That
Yeah,
if
but
this evidence
forget
had been
that
put in.
and forget
So,
that for our discussion.
But in his opinion, there was a family history, including the sleepwalking
Right.
of the appellant's mother as a child, the appellant sleepwalking as a young child, that the appellant, the accused, had other associated sleep disorders, including nightmares and sleep paralysis. That his girlfriend's evidence was that he had engaged in sexual activity on prior occasions while asleep. And on one occasion, she awoke to finding him apparently asleep and masturbating in the bed beside her. He was completely unaware of this. Alcohol consumption was a triggering factor for parasomnia, and the appellant's reported drinking before he went to sleep. His lack of recollection of any sexual interactions with the complainant, and absence of any other allegations of sexual misconduct, and the inconsistency of the sexual assault with his general character, and some of the circumstances of the assault as described by both the complainant and the accused person were consistent with him having been asleep, and the brazenness of the assault also suggesting that it was not volitional, that it was not something...
That's huge.
Now, let me just talk for 1 second. So it's interesting some of the factors that you look at, because in a regular sexual assault case where you're not running a defense like this, some of this information would be myth-based reasoning, right?
Oh, yeah, that's true.
Well, if you just
That's
focus
right.
on one of those reasons, it's the combination
Right.
of them.
But this is admissible here because you're talking about not disputing the act itself.
Right.
It's just simply, was this volitional?
Right.
So this is a fairly robust foundation of evidence to try and muster the defense on a balance of probability. Okay. Next
Well,
question.
just going back to what we were reading, there was basically a summary of the decision in
DM?
Stone. Yeah, it's from a case called DM 2013 OJ number 5232. But the final point there that we hadn't got to was
Right.
that they sum it up, that in order to satisfy the proper foundation for this defense, that there must be an assertion from the defense of involuntariness, meaning unintentional act,
Right.
and they must call a psychiatric or psychological evidence to confirm that state. And they said, however, it's an error of law to conclude that the defense burden has been satisfied by only doing those two things, which again just reinforces we're saying this is not simple.
No, it's not.
So just making the claim it was involuntary and calling some
not enough.
expert evidence is not enough to satisfy this.
And the burden remains on you.
The burden remains on the accused to prove their defense now.
Okay, so let me raise two issues, and I'm going to do it in reverse order. One of the triggering factors that is consistent throughout many of these cases, and not the one that we have, is alcohol and alcohol consumption. I want to come back to that as a discussion because people will be asking about that.
Yeah.
But I just want to talk about this mental disorder automatism or non-mental disorder automatism, and take us back to BM, and this refers to the Stone case, where
That's the seminal case, the Stone case.
it is,
Yeah.
where Justice Bastarash went so far as to take judicial notice that it will only be in rare cases that automatism is not caused by mental disorder. Bastarash further observed that the trial judges should start with the assumption that the condition constitutes a disease of the mind. That's a particular way of analyzing under the code. Trial judges will then have to determine whether the presumption has been rebutted. And that's an interesting discussion, because what you'll see in the other cases, and particularly in, I think
Our waitress is here, Joe.
oh my gosh, okay, well, we're gonna get the food down, but I wanna continue to talk. Oh yes, baby.
I was trying to clear some space here.
Yummalicious.
Oh my goodness. Fries with gravy.
Diet fries, I see.
Can I take this from you?
Everybody can pick at this.
I don't think there's a
I'm gonna have some
choice.
fries with gravy.
So it's very clear from Stone and in following decisions that,
Soupy.
Thank you.
What did you get?
look
me,
at that,
Marcy?
Burry.
Oh my god.
Can you zoom in on that?
Can you zoom in on that? That's like a major cheat for my diet, but no one's going to see it except
Can I have
all
some
our
water?
viewers.
Yeah, I'll get you all water.
Thank you.
No one's going to see it except how many viewers?
I don't know, we'll
Oh.
see.
Thousands.
Well, hopefully,
Well, this will drive
Cheers.
up ratings.
yeah, this is great.
Burry eating his open-faced chicken sandwich.
This can either be gross or not, but anyways.
Right. No zooming in, like just.
Would you like some pepper?
Oh, sure. Make sure you pan shots. Don't let's.
So while we're eating, let's talk
Oh my
about this
gosh,
for a
this is
second.
so much food. It's unbelievable.
Yeah, I know, he doesn't give small portions, eh?
Oh my God.
Peter's
Diana,
amazing.
How are you going to do that?
You're gonna help me. You got enough. You got your work cut
I
out
know,
for
I
you
got
already.
my work.
So now we know, okay, that
Have to fry first.
that it's a rarity. It's a rarity for these cases, and the majority of time, if not always, this will result as, in the court's opinion, as derived from a mental disorder.
Right.
So we will go down the NCR path. Now, let's talk about triggering factors, and just specifically alcohol, because we know that has been a large bone of contention.
These fries.
That they're good, eh?
I know. It's very distracting.
And the gravy?
Yeah, I know.
No. I love this.
Wow, look at that thing.
That alcohol, if you are drinking large amounts of alcohol, or even a moderate amount of alcohol, that then is a triggering or precipitating factor, should you be able to rely on a defense at all?
Well, a lot
from
of
a
people would
policy
say
standpoint.
no.
Right.
You know?
From a
And
policy standpoint,
not to
no.
distract, but we
We're
had
already
a few,
distracted, man.
No, I'm in heaven at the
We had a
moment.
few
Oh,
big
okay.
cases in the last, like in 2022, I think it was, with
Here we go. Wait, pause.
I'm diving in.
oh,
Uno momente.
Pause. He's doing the first bite.
I'm so familiar with that bite.
I know. I know.
I've seen,
I've
it
seen
a
that
few
bite
times,
many times.
Sadly.
Oh,
definitely isn't it?
Oh, hold on.
he does, but that's part of the
Hold
experience.
on one second. Mwah.
He just kissed the burger, people.
But,
Good
you
work,
know,
Peter.
There was a huge public explosion over cases not to do with sexsomnia, but self-induced intoxication.
Why
and
is
they had
that?
similar concerns from the public, which is, oh, what? Now a man can go out and drink and then rape with impunity?
That's right.
That's right.
And this is very similar in that, intoxication really complicates the defense of sexsomnia. if the person is also found at the time, and we've seen these cases in ones that we've looked up and we've printed out, where when the person was severely intoxicated at the time, they basically didn't allow the sexsomnia defense because they said basically you were just drunk. Really?
Right, so let's be clear. So sexual assault is a general intent offense. Intoxication can negate specific intent, but not a general intent offense.
Right.
Therefore, you get drunk, too bad.
Too bad.
You're going to be guilty of sexual assault.
Right.
It reared its head again a couple of years ago, or a few years ago, when 2 cases went to Supreme Court of Canada, because previously, if you were self-intoxicating from alcohol or drugs and suffered a psychosis, you could not rely on an NCR defense, and you could literally have committed the offense involuntarily, but still be convicted. Went to the Supreme Court of Canada, they said, sorry, that's wrong.
Right.
That's not fair, that's not correct under the charter. In these very discrete circumstances where somebody has a predisposition,
Right.
and they took mushrooms, but they didn't know how it was going to impact them, or a
Right.
certain level of alcohol they didn't know, and then they were in a psychotic
Or
state and
somebody
committed.
got them drunk.
But let's just talk about
But in one of the cases,
self-induced.
the guy was actually trying to kill himself, and he became induced
In that state.
not because he was being irresponsible about drug use, but because
Well, one might argue that's irresponsible, but yeah.
Can't
But
believe
he-
we haven't offered
it wasn't
Max
his intention.
anything. Max, you want a fry? Oh, you got some? Okay.
it wasn't his intent to harm anybody but himself.
Just checking.
And when he attacked the person that he did attack, it was his own mother, and he didn't recognize her, and she knew
That's right.
that. He actually had no idea who she was. So
How can you even fit that in your mouth?
Practice.
I was going to say, that's a lot of stretching exercises.
So that brought back the ability, in very rare circumstances, that self-induced intoxication can still, or doesn't negate, your ability to rely on certain defenses of having a psychotic disorder and then relying on the Section 16 defense.
and those cases were not NCR, like they have an ongoing mental disorder. They were temporary states of delusion.
Those were transient in nature. So, but I just wanted to raise for a moment then this idea of alcohol and then sexual assault. Because there has been an ongoing push that the floodgates will open if anything is allowed. And when these sexsomnia cases came out, I remember clearly, because it was at the beginning of when I was also doing the work to write my book. Well, it's a text because it's updated. And there was huge controversy with this. And saying it's just junk science, it's bullshit. It's not.
Right.
And it's a common factor that alcohol can be a triggering component of this. So should that negate, from a policy standpoint, the ability of somebody to use it if they're truly involuntary, if they're truly asleep at the time because they consumed a large amount of alcohol?
So
What do you think? I know what the legal answer is, but
there's a very good reason why one of the 2 elements required, the actus reus, which is the doing, the act, and the mens rea, the intention to commit the act, is very, very important reasons that those 2 elements must be proven by the Crown. And of course, if the defense raises something admitting the act, then the defense has to prove it when you're claiming something like automatism or whatever. Right.
You still can't pronounce that, can you? You still can't say it.
I used to say it.
she's doing a good job.
She is, though. I
I'm
was
doing
gonna say,
better than I
you're
was.
doing better than
It's
you
like
were.
tomato.
I know. You're getting much better. Sorry for interrupting.
But there's a very good reason why we have those 2 principles required, because
Sure.
we don't want to send people to jail for something they didn't intend to do.
Or didn't do volitionally.
Yeah, that's the main
So
thing.
the way I
intentionally.
look at it from a civil liberties point of view, from a charter-based point of view, if somebody does not have the mental element,
The intent.
if they're acting involuntary, regardless of whether alcohol was a contributing factor, but it resulted in them truly being asleep at the time, and they have other issues, including a history of sleepwalking, there is other collateral evidence to support the finding that this is a legitimate defense, where it meets the balance of probability, it would be wrong to bar it because alcohol was a component.
Right.
So I think, and we know that the courts stand on this, so that this is a defense that can be
People
made
in the
out.
general public still get upset over
Yeah,
it.
people
though.
are have hang-ups.
Well, there are people who, if they watch this or this is posted, for example, on X or whatever, we will get some hate comments where they're saying that we are,
Misogynistic, so-and-so.
well, and we're promoting abuse against women, and alcohol is okay as an excuse, and we're not saying that at all.
No.
Because there's legitimately, I mean, when we're doing, look, I'm familiar with this, but what, 5 or 6 cases? I mean, it's rare.
The occurrence of these cases is like almost nothing.
Yeah, think about it. Trust me, if this went on in a court in Canada, that would garner media attention.
Right.
So this is not something that people
not
can
an
come out and
everyday
say
case.
that this is some floodgates argument
yeah.
and we're letting people off. It's just a reality. There are disorders. They do occur sometimes because an intoxicant can help trigger it. It is not the only contributing component. And if something is involuntary,
It can't be punished for that.
that's right.
It's just not fair.
So it's interesting, you know, we have this case. It's the first time we're going to be looking at something like this, is seeing if this is a defense that we're going to try and argue. And I thought it'd be interesting to go back in time and look at this.
Yeah.
Yeah, but you know, when these cases are public and there's a public outcry, I think there's a lot of misrepresentation about how common these things are. They really aren't.
Of course.
And there's misrepresentation
And
about
it's always like, you
about
know,
the evidence.
The sky is falling. The
course.
sky is falling. If this one person is allowed to argue this thing, then everybody's going to argue
That's
it.
right.
And everybody's going to
Rapists
get away
everywhere.
with crime.
Right.
and there's
It's simply
vilification
not
of your
true.
experts.
That's right. Oh, yeah.
Last thing. Is this easily accessible to anybody to run this defense? Like, or does this cost a lot of
Good
money?
point.
Well, that's the thing is like you need an expert, and a lot of people can't afford a lawyer, let alone an expert.
You may be able to get a lawyer on legal aid for a sex assault, of course, and you may be able to get authorization from legal aid for a psychiatrist, but it's going to be difficult.
It's going to be limited.
It's going to be limited. And in the normal course of these cases, you really need a combination of experts. You need a multidisciplinary approach, a sleep disorder expert, a psychiatrist with expertise, a forensic expert with expertise with sleep disorders,
Private
and then
investigator, potentially, to
interview
investigate
people.
collaborative
And you can expect
facts.
that the prosecutor is going to call their own experts to contradict
Of
you.
course.
you're going to get a battle of the experts. And what I would like to see, you know, and we've been part of this because I had a couple of these cases where, not this in particular, but you had to call psychiatric evidence, less of the vilification of experts and more of an openness to try and get at the truth.
Right.
Because I've seen a miscarriage of justice where somebody who was severely disordered was found guilty purely by the mishandling. I don't want to say it this way, purely by, you know, the zealousness of a prosecutor who just wanted to see this person in jail as opposed to in a mental health facility being treated for a true disorder that they had. So I'd like to see less of the vilification and more of a collaborative approach. And I have seen that in many instances, and I commend everybody who's worked in that regard.
Yeah, I've seen that too with many crowns.
And also in the case of BM 2018 that you mentioned, they do make a point, paragraph
love these
123,
I know you do. You eat just the fries.
really
You
good.
don't
I'm
even
gonna
eat
have
the
a burger.
burger.
that further, there's no scientific research to show just how sleep sex or sexsomnia is triggered. So this lack of research is a big problem for people who may have actually been
Well, who
suffering
knows?
from
That may
condition.
change, but it's still on us on a balance of
I think
probabilities.
the
It's
lack
not
of
an
research
easy-
is probably due to taboo.
Of course,
the truth.
wouldn't surprise me.
Well, if you like what we were talking about, I can't do pillow talk, but I can do burger talk.
Burger talk.
If you liked it, please like, share, subscribe, click
notifications.
notification, send us comments and
Leave
questions.
comments.
Because again, we keep getting a ton of them, and it's really
And leave
helpful.
us stories if you have them. Leave us stories of sleepwalking. That would be really fun.
Yeah. Thank you, everybody, for viewing. Let's finish our food.
Yeah.
Well,
or
there's,
try.
there's still
There's a lot of
dessert.
it.
Diana, you're very slow.
Marks, you want a
tonight.
bite? Come here, have a bite.